I've got a few comments, but I'll give you guys an opportunity to be heard first.
Typically, I'd like to hear your comments first.
Sure.
But you and Attorney.
Sure, and I'll tell you, I spent a number of hours on this as well, and Ms. Phillips and I had a couple meetings about this. As I mentioned, I met with the citizens, 3 of the 4 that spoke this morning, and as we discussed this over time, I think we share 95% of the concern. I really see this as an issue that's divided into 2 questions. One, whether or not a system is appropriate generally, and then number 2, how do we accomplish that? Because there are a number of concerns that I have about a system, many of which, in fact all of which were enunciated by Ms. Phillips. Namely, I have great concern about, number 1, the fact that these records do belong to the county, and that the state shouldn't usurp that authority and tell us what's going to happen to those records. So as I've discussed this with Ms. Phillips, I certainly believe that any system that's developed needs to have an opt-in or opt-out provision for counties, so that we then can decide the fate of ultimately between the clerk and the Commissioner's Court as to what happens to the records that we're responsible for. Number 2, fees related to that. Just you never want to see the state come in and capture fees that are otherwise going to the clerk's office for things that are being acquired. Then you also have the privacy issue. That's a big deal for me. This confidentiality issue needs to be threshed out by the OCA and the JCIT and the Supreme Court. It appears to me that this discussion really was a discussion probably that would have been really great to have 4 or 5 years ago before they got the train moving. I think the train's moving fast enough now that what I think we need to do is provide enough constructive feedback to the JCIT and the OCA that they don't move too fast and they don't screw up with confidentiality issues, privacy issues, access issues. For instance, I would suggest that when we talk about a PACER-like system on a state level, PACER, for those of you that are not aware of it, as an attorney, I've accessed PACER for years. I mean, maybe a decade probably. And anytime I file a document, I have to click on there that I agree that I have read the rules of confidentiality and have redacted all sensitive information. I'm sure, and Nathan Hecht, by his resolution, indicates this, that they are acutely aware of the need for privacy. Now, there can never be a fail-safe system, and herein lies kind of the balance, I think, because you end up with we believe in public access to documents. We want litigants to cases to have access to information. They can already get it if they come down to the clerk's offices. That information, there's not going to be any new disclosure. It's just a different method of disclosure. So you say, well, what are the dangers there? Well, you always have a danger of electronic intrusion by somebody that shouldn't have access to those documents, and that's a big concern of mine. As I talked with Ms. Phillips, one of the things that I noted that I thought we needed to communicate back to the OCA and the JCIT is, you should never allow someone with a foreign IP address or someone with a foreign address to access these records. Username and passwords are already mandated and will be part of this program if it gets up and going. So you're going to know who accesses those records. That's vitally important. Another conversation piece that we've had is about Harris County. Aside from the federal PACER system, Harris County's been doing this for years. When I practiced law in Harris County, I had a login and password, and I could access any document that was not a confidential or had sensitive information document in there. Any document that was a public document, I could go down to the clerk's office and access. In paper form, I could log in and see that document and pull that document down on the computer system. It saves time and money for clients, and those clients are our citizens. And one of the examples I gave in the discussions with the citizens was that there's been several times when I've had cases across the state, and I have a specific recollection of a case where I had to actually call and hire somebody to go down to the courthouse in Midland and pick up some records for me to send back those paper records to me for a case that I needed here locally, and that cost my client a whole lot of money. And when you're talking about folks that don't have enough money to access justice, we don't want to make the bar so high that they can't do that. And in a lot of sense, this provides them the ability to, those that are poor and indigent to be able to access justice a little bit easier, in my mind, as long as it's in a safe manner. So those are some of my comments. Again, I appreciate Ms. Phillips raising this issue, because I do believe, and I want to reaffirm this, if the state moves forward with this system, I would urge them, regardless of how I end up voting on this resolution, I think that there has to be an opt-in, opt-out. Ultimately, we're the record bearers here. You're the custodian of records for the county clerk's office, and Ms. Rogers likewise for the district clerk's office. I think the county needs to opt in or opt out and have that option. But when you talk about counties that have 2,500 people in them or 5,000 people in them, they can't set up an independent system like Harris County can. They don't have the funds to do that. So allowing counties to opt in to a managed database statewide, if they choose to do so of their own free will, I don't generally oppose that idea, as long as it's done appropriately and with safeguards in place and audits in place to the third-party vendors that are doing it, to make sure that there's no security breaches, or making sure that the security measures are up. And again, like I mentioned, with no foreign access and confidential proprietary information and personal information redacted. Those are important components, but that is the how. That's not should we, that's how should we. And so I see those questions really as two different issues, and that's really the only point of difference between me and the County Clerks Association on this resolution is I don't generally oppose that. And if we were asked the question, should this county opt in or opt out, I would urge the county to opt in if those measures that I've mentioned are put in place. So generally, I think this is a great way for citizens to access justice more appropriately, but there are a lot of pending questions out there, as Ms. Rogers mentioned. There are a lot of potential unknowns, so I understand that there can be certainly two reasonable positions on this moving forward, but whether or not we do it, generally I would say we need to move towards that era, but how we do it, there are certainly some concerns that I have. Any questions about my comments or